disability isn't easy. Let's talk about the problem of selective omissions by disability carriers and plans. So, let's talk about what happens behind closed doors and even behind closed files. The carrier may have asked you to sign a release to get your workers' comp file or ask for other information, and you feel as if you're obligated to give them the entire file, including stuff that's not favorable. So here you are, what are you going to do? If the policy requires you to produce it, or the nature of the request is that you've got to produce the stuff, even if it's unfavorable, then I think you have to submit it. By the way, I need to let you know that sometimes they will use a general release that you've signed and go to the comp carrier and try to get it. And heavens knows in that case what the comp carrier has sent to the ERISA disability carrier, which causes another set of problems. But let's say your comp case has been denied, your ERISA case looks like it's going to be denied, and you are being asked to provide this information. Now, remember that you have an obligation, I think, depending again on the request, to provide that information. And the disability carrier looks at this and decides that they like those nasty reports from the workers' comp doctor, or that nasty IME that you had, or the nasty decision from the workers' comp judge that says, you're not disabled, you're able to work. And they use that as a grounds to deny the claim, conveniently ignoring anything that's favorable. You have an obligation to file an appeal within 180 days of that denial. And if you don't, you're going to lose your rights to proceed. You have to exhaust your administrative remedies by filing an appeal. That appeal is the trial of your case in the context of an ERISA case. And so you want to make sure that everything that's favorable is in that case, including any favorable workers' comp stuff. Now, if you file the appeal and they deny it, you might have the right to a second level appeal, or your general option is to give up, which I never recommend people do, or your third option, and the more likely option, is at that point to file a lawsuit in federal court, because the ERISA disability carrier plan is not necessarily going to change their mind once they've issued a final denial. So when you file a lawsuit in federal court, the court only gets to look at the material that was in the carrier's file or the plan's file at the time your claim was denied. And under the federal rules, the carrier has to give you what's called the administrative record, which means this is the record that they relied on in making its decision to deny or terminate your benefits. And guess what? You and your lawyer start looking through this administrative record and you note that something is off. The key reports that were favorable to you, the medical reports, the IME, the vocational report that are in the work comp file or that you supplied, are missing. It might be a physical therapy note that says you couldn't safely return to your past work. It's not there. It could be a favorable IME, and it's not there, even though you know it exists. It might even be a deposition that you submitted that was favorable to you, but it's not there. And you're wondering, was this a mistake, or did the carrier intentionally remove supportive information? So what I find, regardless of whether it involves a comp case or maybe even a personal injury case, there is a selective omission on the part of the disability insurance carrier plans. They cherry pick the medical records and the evidence to support a claims denial, and they leave out the stuff that, doesn't, help you. It's just not shady. I think it's potentially illegal under the ERISA statute and regulations. The administrative record is to include all the materials that were relied on in making the benefit decision, that were either submitted, considered, or generated in the course of making that decision, even if they didn't ultimately rely on it. And they have to demonstrate compliance with the process as required by law. So in English, or in other words, if it was reviewed or created as part of the claims process, it should be in the file, period. But here's the kicker. Most disability carriers or plans know that the claimant is never going to litigate the case. It's a license to steal. And they know as a result that the courts will never see the administrative record. So unless you file a lawsuit and challenge this, they have gotten away with basically cherry picking your workers' comp records and using that as a justification to support their denial or termination of benefits. Unless you challenge them, unless your attorney demands the full record, they can get away with this cherry picking. I will tell you, though, when courts catch this behavior, they don't like it. Judges have been known to reverse denials and order carriers to reconsider their decision when the records were clearly withheld from the administrative record. And we do that by raising that issue with the court. But obviously, that's why we suggest that you keep a log of what records you've submitted to the disability carrier, including any information from your workers' comp claim, so that you know ultimately if the claim is denied, what you submitted. And then that you can ultimately create an affidavit under oath that will tell the court that this was submitted, or your attorney will do an affidavit that says, hey, you know, we're the work comp attorney, or we're the ERISA attorney. We got the work comp file pursuant to their request. Here's what we submitted. Here's all this, and attach it. And by the way, this is what was not produced to us in the administrative record, or not cited in the appeal letter. And we believe that the carrier of the plan has violated ERISA regulations, and you, the court, should be allowing this in as a supplement to the record and considering it in your decision as to whether or not the claim was properly denied or terminated. You can hear that this is a complex issue. You're dealing with a work comp carrier and an ERISA disability carrier or plan whose profits depend on denying claims and upholding that denial. They're going to be using every weapon in their toolbox, including hiding stuff, cherry picking stuff, misconstruing stuff. And again, this is something that you should not let them get away with. It's something both you and your lawyer need to be working on together, and quite frankly, something you should not be handling. So again, the answer depends as to what should be produced, depending on the policy, their request, what's in the workers' comp file, and of course, if the attorney's involved, the rules of ethics. And again, when you get in a situation where your claim has been denied or benefits are terminated, you need to make sure that all that favorable work comp stuff makes it into the administrative record. If it doesn't, that's one of the great reasons to challenge the denial as a violation of the rules or regulations. Carriers don't play fair, and they need to have their feet held to the fire to make sure that you get the benefits you deserve. Got it? Well, thank you for tuning in today's episode of Winning Isn't Easy. If you found this episode helpful, please take a moment to like our page, leave a review, share it with your family or friends, and subscribe to this podcast. Thanks for listening, and we look forward to joining you again in our next episode of Winning Isn't Easy.